A very good morning and welcome in the ring to this very special coverage of Decision Day, Elections Petition 88. The decision is going to be handed down at 11 o'clock, and I'm tremendously privileged to be joined by my colleague Randolph Critchlow, who will be with me, walking us through the paces as the decision is handed down and for some reactions afterwards. Randy, a very good morning.
Hi, good morning, Sherrod. Good morning, Guyana. Everyone joining us right now on this. We're on at a strange time, of course. We're normally on covering all of the big events. Today, of course, is the decision day for petition number 88. And we'll be joined by Mr. Christopher Jones in a few, getting reactions from those persons who are in the field. Um, of course, there's a crowd assembling at the Square of the Revolution. So we'll be joined by Christopher Jones, who will be our man in the street for this particular special broadcast today. Folks, we want to encourage you to share the live stream. Share the live stream as we bring you informations, reactions, thoughts, everything coming out of this particular day. A reaction, of course, from the ruling that will be coming down at 11. So again, ensure that you share the live stream. And here's some song. I think that is Shara doing some sharing there, right? So we encourage you to share the live stream. Let your friends and family know that we are going to be doing our show, getting reactions from the petition 88 decision day at 11. We'll be hearing that ruling from Chief Justice. Let me go right now and share some other places so that we can be live. We can be bringing you
Correct,
the
Randy.
information as it happens all around. Sharon, I'm just sharing it at a few places now, and we encourage our friends who are joining. As usual, I like to ask where you're joining us from, right? I like to ask where you're joining us from, right? Right. So wherever you're joining
And
us from right now, just let us know in
if
the comments. Sharon?
Randy, just to alert persons who are joining us, so we are going to be bringing you some commentary right up until the decision of the Chief Justice Roxanne George Wilshire is handed down. We are going to break for that here, carry part of that presentation at the High Court for you. If we have any difficulties, though, we'll take a break and we'll post that link directly on our page. If not, we're going to stay and give you continuous coverage. But we're going to be back after the decision is handed down by the Chief Justice to bring you some commentary and get some reactions after that decision in the Elections Petition 88 has been handed down. Randy?
Yeah, Sharon, I'm just sharing. If you can take off the bottom screen there from the live feed right now. They're not quite ready. They're not quite ready. Yeah. Just take, you could, looks like we're getting some live feed from what is happening, but it looks like they are ready now and they are moving. Folks, as we said, we'll be bringing you images and videos from what's happening around the town as persons make their voices heard. Shared right now, I'm just sharing at a few more places so we can get everyone involved in what is happening here. Just bear with us, viewers.
Correct. And
yeah.
Correct, Randy. And we encourage those of you who are viewing us, whether you're joining us on YouTube, on Twitter, on Facebook, to share the live stream. We want as many persons as possible to be able to benefit from the information that we're going to give to you guys this morning. As Randy always says, credible and valid information.
Credible and valid. So we've shared on a couple of places. Yes, decision day shared. This is highly anticipated. It was 7 months ago, 7 short months ago that this petition was filed. And sorry about that. I think my phone is on. This petition was filed. So again, those persons who are live, share the live stream. Let your friends and family know that we are live right now on the air, and we're bringing to you credible and valid information. But it was 7 months ago that this petition was filed, and of course, they were asking for a swift petition, and many persons were surprised at the speed at which the petition ended up being heard. Shared, were you surprised that it was heard so quickly?
No, because one, as you said, it is what we requested of the court, and I think the court would have been hard pressed not to do so when it availed itself during the election process to hear cases coming before it that challenged the validity of the elections or challenged at least various parts of the election. So it would have been remiss of the court to not hear it as swiftly as it was hearing those cases.
Yeah, definitely. I believe that that was part of the pressure to hear it because, of course, the world and the entire country, they were privy to all of these speedy cases that had to do with elections. So it would have been remiss in the court not to hear this matter of national importance in the same sort of alacrity and speed and urgency that they did throughout the election
Correct.
period. Right. As we
Correct.
said, we'll be joined. But quickly, for just for our viewers' sake, we want to give them an idea shared of what Petition 88 is all about. If you weren't following and you don't know, you just tuned
Yeah.
in to the entire election saga here in Guyana. Petition 88, and Sharon's going to expound a little more, deals with the validity or the constitutionality of Order 60, which was used by GCOM to remedy the situation that was happening during the election and recount. We had a national audit of all of the boxes. And of course, Order 60 was the platform. That was the basis for the going in, the auditing of these boxes. But of course, there were many contentions, many contentions by the GCOM's own legal counsel, Ms. Excellence Dazil, and the Chief Parliamentary Counsel, Mr. Fongafat, positing that, look, Order 60 creates basically, and I'm using the words here of the CCJ, creates a new election regime. And only Parliament has the authority and the power, the constitutional power to do such. So GCOM could not create this order that basically changed the laws of Guyana. And it had no sound bearing in the law, and it basically was unconstitutional. These were words coming from legal minds. So we ended up in a position where Order 60 was used, and shared for those persons who may not be up on what is happening. Once we stepped into the realm of Order 60, we then moved from what the Constitution demanded, in that a declaration was supposed to be made based on the 10 declarations by the returning officers of the 10 districts.
Yeah.
Right? So we moved away from
Yeah.
that, and we went into the realm of using whatever information was gleaned from this recount.
Yeah. And at least that is the contention of the coalition lawyers, if you want to put it in that way, to give persons a simple understanding, that a declaration had to be made first
Yes.
as to the outcome of the election before you got to a recount. That
Yes.
is always what the law says. And especially at the national level, a declaration must be made, and then you can have a recount afterwards. And so that is the main thrust of the contention and of course we're going to get some more into the weeds when we talk with some of the legal luminaries a little later on in the morning.
Quite interesting, Shared. Those 10 declarations, of course, saw that the APNU, or based on those declarations, the APNU AFC would have been pronounced the winner of the elections. And so there are many questions as to if this decision comes down on the side of the APNU AFC, what then is the legal position? What then is the constitutional position? If we are going to say to me that Order 60 is deemed unconstitutional, invalid, null and void, do we then revert to the situation that existed before Order 60 came into being? That is the use of the information from the 10 declarations which saw the APNU AFC winning the elections. And then what? Then what?
Yeah, that is going to be the question for this Chief Justice to understand, to tell us, to explain in the remedies flowing from the judgment. But we,
Yes.
we have with us former Minister of Telecommunication, Member of Parliament, the Honorable Catherine Hughes, joining us from Ground Zero, the square of the revolution, where hundreds of Guyanese, if not thousands of Guyanese, have assembled. And I want to get some reactions from her, Randy.
Yes.
Hi,
Kathy, a very good
gentlemen.
morning. A very
Good
good morning.
morning. Good morning. Are you
Morning.
hearing
Welcome.
me? Are you hearing me loud and clear?
Loud and
Yes.
clear. Loud and clear. What's happening where
Great,
you are at
great.
the Square of the Revolution?
Well, as you can see, let me show you. We've got loads of persons out here. Everybody's here in their numbers. We are standing in solidarity. We are happy that this day has come, and we know that Guyanese of all walks of life want to ensure that we get a final judgment and decision on
Yeah.
an election that has gone down in history as one of the worst times Guyana has seen. I
Yeah.
see, as you know, in terms of some of the issues, here's a young man. He's talking about the harassment of our brothers. I will ask him to say a few words to us.
Um, Former Minister, I think the earpiece that you're using, you're not getting. You have to put the microphone piece a little closer to him.
Okay, okay, okay.
Hmm. Yeah.
So why you're a young Guyanese man? Tell me why you're standing here today.
I am standing here today the, because the youths nowadays they are not getting jobs, quality jobs and those things. They are not paying the rightful money they're supposed to pay, and they are abusing children.
And how do you feel standing here will impact on your quest for a fair life and your right to have a job in Guyana as a young man?
Yes, I would like to say that at least they should me say that they must give small ones, but at least give a certain age, like 17 or so, give them a try, see what they can do, because you never know.
No, you're absolutely correct.
You never
Um,
know until you see them. Sometimes they might come out perfect, sometimes they might come out, I ain't saying everybody gonna come out better, but some of them gonna come out good, some of them gonna come out
Good. Well, thanks for talking to us. Thanks for talking to us.
bad.
Right.
Gentlemen, as you know, we're working with limited internet access, but were you able to hear what the
Yes, we
young
were.
man was saying?
Yes, we were.
Yes?
We were able to get that. And let me just
One.
ask you. Let me just ask you a question. We it is decision day for this petition 88, which of course we were discussing with Chair just now, deals specifically with law. But are Guyanese still interested or still um, up in arms about all of what we found out during the election, which of course is in petition 99, which will be appealed on the 12th of June. But how are Guyanese reacting to
Well,
the fact
Randy,
that we found out all of these things about the elections?
Randy, the best way for me to answer that is to let you speak to the same Guyanese person
Yes.
that are standing here in their numbers. I'm here
Yeah.
with a gentleman. His placard, of course, says "Stop harassing our fathers," and we know that there are many incidences of Guyanese being harassed since this change in government. So I will
Yes.
ask the gentleman, sir, would you like to say a few words to our camera? Why are you here this morning?
I'm here to ask the authority to please stop harassing our father.
Okay. Did you have a particular incident or case of this happening?
No, I don't, but I stand with the country, the whole country
Yeah.
that is going through this disaster this time. Not only our father, our mother, all the public servant people they are harassing.
Yes.
We are struggling in this country at this time.
Mhm. And sir, can you tell me what are your thoughts? How do you feel today? I know it's a difficult day for many people. We're worried. How are you feeling today? And what would you say about the court system and what you're hoping to hear?
We are hoping to hear positive thing that we have win the petition today because we have that confidence that we have win the election.
Good.
Right.
Thank you very much, sir. Thank you very much.
Yes, we got that. We got that. Again, this is what I was inquiring about, how the people are feeling about how everything played out. We know that at 11 we'll hear a judgment on petition number 88. I think we have Sherrod joining us again. Sherrod, your microphone.
Randy, in the meantime, I do have another lady I'd love to let you talk to.
Go ahead,
Right
go
ahead,
ahead.
Kathy.
How are you doing this morning? And tell me why you're standing here.
I'm standing here because of the harassment in our country as Guyanese. In the whole, we are very much interested
Let me
and
get
we
the face
want
her a little
peace
better.
in our country. And the installed government should go. And we should have peace in our country. Guyana is a beautiful place and we the Guyanese need peace, job, and we need everything as others need. All the Haitian people are harassed. Whether you're Indo-Guyanese or
We're not seeing
Afro-Guyanese,
her
you
face. We're
are
not seeing her.
harassing by the president people. The PPP is harassing us a lot. Mr. Darambal especially, he is throwing us out of bread and he can't give us water to drink. So we need them to go. Today they must go and we must get back what we lost. They had it for 23 years and they did nothing for us. We had it for 5 years. They take away 2.5 years from us. We had it only for 2.5 years. And now we should get it back in full. We the Guyanese need our country. Guyana is our country and we need it. We need it and we need it. We need Guyana. Today we need justice.
Madam, I heard you talking about the importance of peace. Tell me about how you feel with regards to the peace that is now not there in our beautiful country.
There's no peace within any area in Guyana. Any community in Guyana, there's no peace. The PPP supporters are very disturbers. They disturb anybody at night, day, or whatever. Our crime rates are going up. Our children are scared. Our grandchildren are scared. We, the parents, we, the grandparents, also are scared to let our children be on the road. Women, especially, are very scared to be on the road because women are very harassed by PPP men. So I need peace. We Guyanese need peace. We were living in Six Nations and we had peace. And we need that peace again, again and again. Peace, please, Mr. Installed President.
Thank you very much. Thank you very much. Anybody else here would like to express how they're feeling this morning and why they're here? Can I?
We here for the petition and we hope everything go well. That they have to come out and our president install back because this president ain't make it. He ain't make it at all. Everything that you tell him to do, he gotta do. He don't think on his own. That's all I have to say.
Okay. Thank you. What about the petition itself and the hearing today and what we expect to hear from the court? What are your thoughts on that?
Well, today for the petition, we hope everything go well. Rocker and George make up your mind which you really want because this previous government ain't make it. Nothing for the people. Only for their own use. Nothing for the people.
Okay. Thank you very much. Randy, there you heard it.
Yeah.
And we'll let you gentlemen talk for a little while. We'll show you some shots and we're going to another person.
All right. Thank you.
Coming back.
Thanks very
Oh,
much, Kathy.
actually,
Randy-
we have one other person here, ready and willing to talk. Good morning, madam. How are you?
Good morning.
today?
Good morning, Guyana. This morning we are here before the court, just waiting that the law must be the law and that the judge make the right decision because we right now is under pressure. Our children are under pressure. Our communities are under pressure. We are being harassed in many and various ways. And today we come out here to voice our concern, to stand with Guyana, to stand with our people. We know some people, because things is right with them and the buckets and everything is full and the basket is full, they're not concerned about the small man. So we, the small man, is out here standing and hoping this court will belong to Guyana, the government, and the people and the nation of Guyana, that the judge would make the right decision on this day.
Thank
That's
you
my
very much.
concern.
Thank you.
Thank you, Guyana.
Right. Thank you very much. 4 minutes to close. Sharon? Your
Randy,
microphone,
you
Sharon.
guys can tell me when you're ready to come back to us.
Definitely. Definitely.
Great,
Thank you
great,
very much.
great, Kathy. And we are going to be gauging what is happening on the ground there where Kathy is, former Minister of Telecommunication, current Member of Parliament. And also we are watching to see when the ruling starts at the Supreme Court, the High Court, on the Chief Justice Roxanne George Wiltshire, who will be handing down that judgment, Randy.
Yeah, definitely. Sharon, you're hearing from those persons there, right? You're hearing from those persons. And we could probably take down the live feed from the ground until they're ready. We're hearing from
Yeah,
those
and
persons there.
I thought that there's so much that we could unpack from those two persons who give
Yes,
their
yes,
comments, Randy.
yes,
In the first
definitely.
instance, people are talking, this nation is talking that even if they wanted to give the current installed administration a chance, they have blundered so badly. They are perplexed, they are besieged on every front. Look at sugar, what's happening? No remedy for sugar. Sugar workers bawling out for more pay. The industry isn't doing anything different than the promises that they would have made. Look at what's happening. People in the private sector who have big businesses and manufacturing enterprise are saying that they've never experienced blackout like this. Glenn Lal, the owner of Kaitro News, was talking just recently, has never seen blackout like this. In the midst of that, look what's happening at Guy Oil and GPL with the oil scandal that you've been covering extensively, Randy. On every front, it's something. Look, just last week, the Georgetown Chamber of Commerce came out and talked about the escalating crime situation. The president himself acknowledged that crime is going up and said that they're trying different strategies. On every front, in every sector, they are tremendously challenged. What the coalition administration did effortlessly for 5 years is tremendously challenging to the current administration. Randy?
Yeah. Yeah, I concur, Sharon, and I want to say something. I know you mentioned just now about the consequences that would flow from a particular decision, right?
Yeah,
But let me say this to you. If we are talking about consequences, right? Let us think about the consequences that flowed from the like I would say the unconstitutional Order 60 and the implementation and then the use of that Order 60 and then of course the deviation from what Order 60 stipulated and the intention of Order 60 to come to a final credible vote count. You didn't come to a final credible vote count. So you had, for me, an unconstitutional order that you didn't comply with anyhow. You did your own thing. And then subsequently, now we have all of these negative consequences flowing from that decision. That one decision that led our country down this path of corruption and crime and just shambles. So we've had 8 months of massive corruption. It is unbelievable.
And we haven't talked about the elephant in the room, which is COVID that is spiraling out of control. So you have all of what you're talking about, a very sluggish economy, 2 budgets later, no raise to public servants, but COVID has been the one thing that perhaps has dogged this administration that claimed they had the answers to the economy, they had the answers to the sugar industry, they had the answers to crime, they had the answers to employment. But people on the ground know, people are feeling it, and that is why from the square of the revolution there at the head of Brick Dam right down to the High Court, people are making their voices heard in this demonstration, and for various reasons are supporting what is happening and want this election to be overturned.
Exactly. Because I believe Guyanese have had 8 months of this administration, and they continue to beg and cry for some sort of relief from this oppressive regime. I think we are live again with our team out there.
Good morning. I see you here with an important. I know we got some background music.
Go ahead.
Tell me, why did you feel it important to be here this morning?
Because my parents have been knocked out from
job, and I also looking for a job as well to survive.
Okay.
We need jobs.
And can you tell me, how do you feel? Do you feel that the job opportunities are there? What is your take on what's been happening in the last 6 months, and why this court case and this decision is going to be so important?
It will be important that if the government can look into both sides, not one side. We are one six. We shouldn't be focused on one races.
Okay.
One people, one nation, one destiny.
And what do you have to say about the pending decision? And your thoughts, how you feel this morning?
I feel that we need justice. We need everyone to speak out. The government needs to see this.
Okay.
Right.
Good. Thank you very much. Thank you very much. Madam,
Thank
any
you
of you ladies would like to say anything? I know you're all here.
Something in one word. That really need help. Need help, and getting nothing at all. It's one side alone.
Okay.
And they're looking into us. Lovely, and they might be something more. And I can't say no more. They won't be out in nothing.
So can you say why you can't sell in the market anymore?
Them harassing you. You ain't getting the things you want them because people ain't coming to buy as I can tell them. They don't come to the market so much.
Okay. Okay.
Do nothing, they looking for jobs or look something and go there spending money.
Do you have children, madam?
Eight.
8. Oh, there. So it's hard to manage.
Yes. One from
We're not getting the sound too clearly.
Okay.
Right.
Of
Thank you
course,
very
Randy,
much.
I know
Yeah.
there's a
Thank
lot
you
of
very much.
songs around. I don't know
Yeah,
if you were able to hear.
We got most of it, and we're happy that you're bringing the comments on the people on the street. I think the actual hearing has started, so we're going to try and bring that to the people so they know what exactly is happening in the court, and then we'll come back to you on the street, Kathy.
Okay, good. I think we're gonna come down. We're gonna come up and get you up there.
Microphone.
Randy, you're absolutely right. We're juggling so many things at the back end. Apologies there, but we are watching to see when the hearing starts. We know that they are live, but as soon as the Chief Justice starts talking, we're going to bring that to you guys live. And if we have any technical difficulties, we'll just post the link directly on our page. But all seems well at this time, and we are going to, as soon as the Chief Justice starts, we're going to bring it to you live.
Sure. Let's talk about scenarios here, and I want to pick your brain a little bit on what ifs. So let us assume that the law is upheld, and this ruling comes down in favor of the APNUFC. If you're very confident that as the case, given the law that is on a debate right now, what are the likely scenarios? I know you don't know what the Chief Justice is thinking or how, what are the consequences that will flow from it, as you said, but what are your thoughts on what should happen after that? Microphone.
When we are successful in this petition, I think that the other side are going to ask for a stay, whatever are the rulings that flow from this, whatever are the remedies that flow from it. They're going to ask for a stay to appeal this matter. And we know either way, Randy, that this matter is going to the CCG. And we've had, for instance, the parliamentary secretary's case, which the Chief Justice said quite recently that 2 of the PPP's parliamentary secretaries are squatting in the National Assembly. They're there illegally. The PPP has already signaled that they're taking that case to the CCJ. This is a case that goes to the heart of their right to govern, and so you can expect that they are going to take this to the CCJ either way. And the same on this side, I can expect that our team is gonna take this to the CCJ if it doesn't go our way. But we have every confidence that the law is on our side.
Right.
The ruling is starting, Randy.
Okay, so we'll go straight to that. Those persons who are joining us live here, we're going to bring you live footage from inside of the courtroom, so you hear what is happening there at that ruling. So stay tuned.
The matter, action number 568 of 2020 FD, the sin.
I'll now read the judgment of the court. Please be advised that shortly after the hearing is complete, you will have a copy of the judgment by email.
Bear with us. We're going to be right back with that in 1 second.
The applicant, Ms. Engel Jones,
1 second.
proposed that she is a citizen of Guyana.
Bear with us for a second there.
Who was a registered voter and who voted at the March 2nd, 2020 national regional elections. She is supported in her application by Danish Maipo,
who deposed he was an accredited counting agent for the APNU AFC at the elections and participated in the recount process, the declaration of the results of which are the subject of challenge in this application. As is well known, the national and regional elections took place on March 2nd, 2020. The post-election day storm to which I referred in my judgment of March 11, 2020 in Holodar and the returning officer Mingo and others has not as yet calmed. Over the past 4 months, there have been continuous contentions and contestations as regards the results that should be relied on by the first respondent, the Guyana Elections Commission, GECOM, in order to declare a winner, and by extension, the President of the Cooperative Republic of Guyana. After the Holodar case, The returning officer for District 4, about whose declaration it is common knowledge there is the most contention, made a declaration of the results of this district on March 13, 2020. This completed the declarations for the 10 electoral districts. Subsequent to the Holodard judgment, and during the pendency of contempt proceedings against the returning officer for District 4, a decision was communicated by the chairperson of GCOM in court on the said March 13, 2020, that a recount of the votes cast at the elections would be conducted, no doubt to assuage the contestations. It was soon thereafter revealed that President Granger and the leader of the opposition, Mr. Bar Jagyo, agreed to a recount of the votes cast, then stated to be under the supervision of CARICOM. This recount agreement was challenged in Moore and GCOM, FDA 394 of 2020. I'll refer to it hereinafter as Moore, which ultimately engaged the attention of the Court of Appeal, which rendered a decision on April 5, 2020. Following the Moore decision, GCOM issued Order 60 of 2020, which I'll refer to as Order 60. Order 60, which was made pursuant to Article 162 of the Constitution and Section 22 of the Election Laws Amendment Act number 15 of 2000, permitted the recount of the votes cast in all 10 electoral districts and a declaration to be made of the final credible count. According to the order, the recount was to be undertaken, executed, and supervised by GCOM and scrutinized by CARICOM. The third respondent, CEO of GCOM, presented a report on the recount results of the elections to GCOM on June 13, 2020. As a consequence, on June 16, 2020, the chairperson wrote the CEO requesting him to prepare and submit a report by June 18, 2020, based on the recount results pursuant to Article 177(2)(b) of the Constitution and Section 96 of the Representation of People Act. Before the CEO could submit this report, another application was filed. This application, Eslyn David and Chief Elections Officer, Civil Appeal number 41 of 2020, was made to the Court of Appeal pursuant to Article 177(4) of the Constitution. In a majority decision, the Court of Appeal held that in ascertaining the votes cast for the purposes of Article 177(2)(b), declaration of the President, GCOM had to rely on valid votes cast. Justice Reynolds, who agreed with the decision of Justice of Appeal Gregory, further held that Order 60 created a new electoral regime which established separate elections, one for the presidency and the other for the National Assembly. Justice Rishi Prasad dissented in some holding that the application was misconceived. The seventh and eighth respondents herein, who had been joined in that application, were dissatisfied with the decision of the Court of Appeal and appealed to the Caribbean Court of Justice. The CCJ rendered a decision in Ali and Jagyo and David on July 8, 2020, overturning the majority decision of the Court of Appeal and nullifying a report with elections results that the CEO had submitted on June 23, 2020 to GCOM during a three-day stay of the Court of Appeal decision. Subsequent to the decision of the CCJ, on July 9, 2020, the chairperson again wrote the CEO requesting that he submit an Article 177(2)(b) and Section 96 report on the election results based on the Order 60 recount. The CEO did not comply with this request. After further correspondence between the chairperson and the CEO, he finally submitted a report on July 11th, 2020, that was not based on the recount results, but apparently based on the 10 declarations submitted to him by the returning officers pursuant to Section 84 of the Representation of the People Act, the RPA. On July 13, 2020, the chairperson issued a ruling in which she stated inter alia, and I quote, "The CCJ did not determine that a final credible count could not be established, neither did it set aside Order 60. The intent of Order 60 was to determine the final credible count by recounting all the ballots cast on the 2nd March from the boxes. Clause 14 of the recount order provides that the Commission can make the declaration from the final credible count of the results. It is my decision that the results of March 13 declarations cannot be used at this time, since these were replaced by the tabulation of the votes at the recount process, which was hailed by all to be a transparent and credible process," end quote. The chairperson again requested the CEO to prepare a report by July 14, 2020, based on the recount results. Then this application was filed by Ms. Jones. Applicant's contentions. The applicant in brief contends that Section 22 of the Elections Laws Amendment Act, pursuant to which Order 60 was issued, is unconstitutional. She also contends that as a consequence, Order 60 is invalid, and as a further consequence, that the recount results flowing therefrom are invalid. As such, she is stating that Order 60 is unconstitutional. She relies on the CCJ decision in Ali, stating that the CCJ nullified Order 60 and relied on the RPA in arriving at its decision that the Court of Appeal had erred in concluding that it had jurisdiction to hear the David case. It is contended that there has been a violation of Section 84(1) of the RPA by GCOM by its refusal to accept the declarations of the returning officers made pursuant to this section. She deposed that these declarations, which were all submitted to the CEO by March 13, 2020, when District 4 was declared, are still extant and valid. She urges that these declarations should and must be the basis for any declaration of the winner of the elections, and by extension, the declaration of the presidency. It is her assertion that the chairperson and GCOM cannot refuse to act on the CEO's report in this regard, nor can he be directed to utilize the recount results for the purposes of a final declaration of the election's results. Her application is supported by the third and fourth respondents, the CEO and Attorney General, respectively. And then I outline the 28 claims for relief that the applicant has sought. The industry of all counsel is acknowledged. I mean no disrespect in not detailing the submissions made. As I did in Holidar, I note that there is much by way of evidence, whether substantiated or not, that has been placed before me in the affidavits as regards how votes were or were not counted, whether or not policy decisions and criteria were consistently applied to ascertain the results each is contending for, and referring to statements made by persons or entities, both local and overseas, with or without supporting exhibits as regards their views on the election's results. Apart from the factual matrix necessary to provide a background to this application, which I have outlined above, none of this information or material is relevant to a determination of this case. Further, affidavits that were filed or exchanged without the permission of the court are struck from or are not part of the record, and have therefore also not been considered. Issues to be decided. Having reviewed the order sought, this application is really a challenge to the constitutionality of the recount process that was undertaken by GCOM pursuant to Order 60. As such, at the Case Management Conference on July 15, 2020, the parties were directed to make written submissions to be heard on the following issues. 1, whether this court has jurisdiction to hear this application. 2, whether Section 22 of the ELA, pursuant to which GCOM issued Order 60, is constitutional. 3, whether Order 60, and by extension, the recount results obtained therefrom are valid, such as to permit a declaration of the March 2nd, 2020 election results based on the said recount results. 4, whether the declarations of the returning officers for the 10 electoral districts made pursuant to Section 84 of the RPA should be acted on or be set aside. And 5, whether these issues are res judicata given the decisions of the Court of Appeal in Moore and the CCJ in Ali. The first issue, whether this court has jurisdiction to hear this application. I understand the gravamen of the complaints by the applicants, supported by the CEO and the Attorney General, to be that the chairperson and GCOM have not complied with their public duty as outlined in Article 177(2)(b) in relation to the declaration of the elections and consequentially the declaration of the president. And that in so doing, they have sought to nullify Section 84 of the RPA. In this regard, they are acting outside the Constitution and the RPA in an election process that is still ongoing, and that therefore their actions are subject to judicial review. The applicant seeks to have Article 177(2)(b) interpreted because, as submitted on her behalf, an impasse now exists between the chairperson and the CEO as to which results are to be used in order to declare the election. In this regard, it is contended that the chairperson is obliged to accept the report and advice of the CEO in relation to the declaration of the results. It is submitted that this impasse must be resolved now and cannot await an election petition. In this regard, the issue is whether the chairperson and GCOM must accept whatever the CEO produces for their consideration as regards the results of the elections. On behalf of the CEO, it is submitted that GCOM, and more particularly the chairperson, are acting in breach of their constitutional and statutory powers in refusing to act on the basis of the report prepared by the CEO, pursuant to Section 9, as the chairperson is constitutionally bound to do, pursuant to Article 177(2)(b), and as such that judicial review can go to ensure that the chairperson complies with Article 177(2)(b). Citing paragraph 42 of the preliminary point judgment in Holodar, dated March 8, 2020, counsel for the AG submitted that this is a case where the court's supervisory jurisdiction can be invoked to ensure the correct and smooth operation or progress of the elections, proceedings, or process. It is submitted that the proviso to Article 226(7) of the Constitution excludes GCOM from the provisions of Article 226, which outs the court's jurisdiction to inquire whether constitutional commissions have validly performed their functions. As a consequence, the proviso permits the court to inquire whether the chairperson and the GCOM are acting lawfully in the context of this case. I, however, prefer the counter-argument that the proviso to Article 226.7 states that even though GCOM is exempted from the operation of the ouster clause in Article 226.6, this is without prejudice to the power of Parliament to make provision in relation to the functions of GCOM. Parliament has done so by Section 140 of the RPA, which provides that apart from an election petition as provided for in Article 1 of the Elections Commission or any of its members has been performed validly or at all, shall be inquired into in any court. The applicant, supported by the AG and to some extent by the CEO, also contends that Section 22 of the ELA is unconstitutional, and therefore Order 60, made pursuant thereto, is unconstitutional and therefore invalid. This, they contend, must be addressed by this court. This is a substantive issue to be determined in this decision, and I will return to this. I note the submissions on behalf of most of the other respondents that this court has no jurisdiction to entertain this application. They argue that the issues she raises speak to an election dispute and are best dealt with pursuant to Article 163 by an election court pursuant to an election petition. Section 140 of the RPA is also relied on. However, it is submitted on behalf of the 5th and 6th respondents that this court does have jurisdiction, albeit limited to where GCOM has acted or is about to act in excess of its constitutional and or statutory powers. In Holodar, as noted by the applicant in her submissions, I held in paragraph 33 of the preliminary point judgment as to jurisdiction that this court has jurisdiction to hear an application regarding whether a person exercising authority has complied with her or his statutory duties. I relied on the cases of Norton and Hamilton in so concluding. The chairperson is a person with constitutional authority as granted in Article 177(2)(b) of the Constitution. Similarly, GCOM has powers under Articles 166(1)(a) and 162 of the Constitution and the RPA. As regards the chairperson, I note the dicta of Chief Justice Bernard, as she then was in the Norton case, where Her Honor acknowledged that, but for the specific ouster of the court's jurisdiction to question the decision of the chairperson of the Elections Commission to declare the presidency pursuant to Article 177(6) of the Constitution, the court had jurisdiction to order certiorari against the decisions of the commission and its chairperson. Justice Bernard clearly emphasized that the court can exercise a supervisory jurisdiction in elections cases outside a challenge to the validity of the elections by way of election petition. More importantly, in Moore, the Court of Appeal by majority overturned the full court decision that the ouster clause in section 140 of the RPA precluded any inquiry into the decisions of the chairperson and GCOM. The Court of Appeal held at paragraphs 84 and 108 that where GCOM has acted or is about to act outside of its powers, that it will be subject to the supervisory jurisdiction of the court. I am cognizant of the restrictions imposed on the court by section 140 of the RPA and by Article 163 that would require an approach to the court by way of election petition. However, in the peculiar context of this case, where there is an impasse regarding the decision-making of GCOM to complete the elections process, and it is necessary to advance this process, which is still in progress, judicial review is necessary to address this impasse. I am of the view that the applicant is really seeking the interpretation of the Constitution for a determination whether the chairperson, GCOM, and the CEO are acting lawfully. It is in this context that there can be judicial review of their decisions. I have further concluded that in this context, there is a distinction to be drawn as regards inquiring into the functions of the chairperson and GCOM, which is restricted by Section 140, and interpreting the constitutionality of Section 22 and Order 60, as well as Article 177, to determine if they are acting lawfully, albeit these provisions speak to the powers and functions of the chairperson and GCOM. Thus, on this narrow basis, it is an inquiry into the legal framework that guides the carrying out of their functions to complete the elections process. If the legal framework is found to be unconstitutional and therefore void, then their functions and actions would perforce be affected. Applying my decision in Holidar and the Court of Appeal decision in Moore, by which I am bound, I hold that this court has jurisdiction to hear this application. Having so found, I now move to the second issue for consideration, which is whether Section 22 of the Election Laws Amendment Act number 15 of 2000, pursuant to which GCOM issued Order 60, is constitutional. The applicant, the CEO, and the Attorney General state that Section 22 is unconstitutional because it confers lawmaking powers on GCOM, a non-legislative body, in contravention of Article 170 of the Constitution. Article 170 provides for Parliament to be the lawmaking body. More specifically, it is pointed out that Article 160 gives Parliament the power to enact laws with respect to the electoral system. It is argued that Parliament cannot transfer or delegate this power to another entity, and that in this case, in conferring on GCOM an arbitrary lawmaking power, it has abdicated its lawmaking power. In this regard, the enactment of Section 22 offends the separation of powers, more especially as it permits GCOM to amend laws even when Parliament is dissolved. In addition, the Attorney General submitted that Section 22 was utilized to produce Order 60 in order to amend Article 177(2)(b) in violation of Article 164, which provides for how the Constitution is to be amended. Order 60, it is contended, purports to strip the CEO of, quote, his constitutionally indispensable advisory role, end quote. This advisory role, as mandated by Article 177(2)(b), means that his advice is to be tendered to the chairperson based on the information from the returning officers of the 10 electoral districts, and that a declaration of the elections results must be made pursuant thereto. The responses of the other respondents are based on two limbs. Firstly, that Section 22 is not unconstitutional, as it did not give GCOM an unfettered discretion to act. It is urged that it is limited in its scope. It is only where difficulties arise, excuse me, in the application of the specified legislation that GCOM is entitled to make provision as necessary and expedient for removing the difficulty. And further, while GCOM is given the power, the period within which this can be done is only for 3 months after the elections. And when Parliament is not dissolved, the power is subject to negative resolution. The power delegated to GCOM being so narrowly prescribed means that the scope of the power was carefully considered by Parliament. In this regard, Article 162 permitted the enactment of Section 22, as the article gives wide powers to GCOM in relation to the conduct and administration of elections to ensure impartiality, fairness, and compliance with the provisions of the Constitution or of any act of Parliament on the part of persons exercising powers or performing duties connected with or relating to the matters aforesaid. It is submitted that given the circumstances of difficulty which have occurred in these 2020 elections, GCOM was lawfully empowered to issue Order 60. It is contended that even the applicant in her affidavit recognizes that difficulties have arisen. These GCOM must address. It is submitted that in any event, Order 60 does not amend any legislation. Secondly, these respondents highlight that this issue is res judicata, as the Court of Appeal has pronounced in Moore on the court's ability to inquire into the constitutionality of Section 22. It is this second submission that commends itself to me. Thus, the answer to this question, in my view, poses little difficulty given the decision of the Court of Appeal in Moore. The Court of Appeal identified the constitutionality of Section 22 as an issue in the appeal. The Court of Appeal clearly held at paragraphs 106 and 107 that they agreed that the legality of Section 22 was a matter to be frontally examined by the court at a full hearing. The court considered the decisions of Petrie and Sikumar Singh and noted and held at paragraph 106 that the High Court declined to examine the constitutionality of election-related legislation during the election period, allocating such questions to an election petition. The court said that such a determination would be disruptive of the electoral process. Moreover, it is well established that constitutional questions can be determined in the hearing of a petition, as discussed in Peters and Chaitan. It was further held by the Court of Appeal at paragraph 107 that if GCOM had utilized or utilizes its powers under Section 22 unlawfully, then this would be a question for determination at such time, and that no sufficient evidential basis exists for such a determination at this point. As such, the submission on behalf of the applicant that the Court of Appeal's decision on Section 22 is obiter dicta when it is based on similar arguments as advanced before this court cannot be accepted. And in Honor's discussion of the effect of such judicial pronouncements in the case of Ying and Song, it has long been the case, that the weight accorded to obiter dicta will vary depending on the circumstances in which those dicta fell, and that considered dicta of appellate courts, though not strictly binding on courts in lower or equal position within the judicial hierarchy, must be afforded great weight and should be departed from only with the greatest of caution, end quote. But the decision of the Court of Appeal on Section 22 cannot be considered to be obiter dicta or a passing statement or comment. The pronouncement of the Court of Appeal was a definitive and considered finding based on a point that was clearly argued. I am bound to give it judicial weight as being part of the ratio decidendi or reasoning of the court rather than obiter dicta. The Court of Appeal, having found that a challenge to the constitutionality of Section 22 would be for an election petition, the principles of res judicata apply. So the issue having been raised and importantly dealt with by the court, it cannot be canvassed again. And even more importantly, since it is a decision of an appellate court, sitting as I am in the High Court, I am bound to follow this decision. I can discern no distinguishing feature that would permit me to depart from this judgment, nor has any evidence been disclosed on the affidavits by and or on behalf of the applicant, such as to permit me to do so. The third issue, whether Order 60 and by extension, the recount results obtained therefrom are valid, such as to permit a declaration of the March 2nd, 2020 election results based on the said recount results. This issue requires more in-depth consideration and really is the heart of the applicant's application. A determination of this issue in her favor would mean that most, if not all, of the relief sought could be granted. The submissions of the parties invite an interpretation of the CCJ decision in Ali. The applicant hinges her objection to Order 60 primarily on the unconstitutionality of Section 22, which has just been addressed. The applicant also submits that the CCJ decision, more particularly at paragraphs 37, 45, and 52, led to the view that the apex court nullified Order 60. The affidavit of and submissions on behalf of the applicant, the CEO, and the Attorney General in relation to this issue are rather nuanced. And here I've quoted from paragraphs 48, 49 of the applicant's affidavit and the paragraphs of the CCJ judgment to which she referred, that is paragraphs 37 and 45 and 52 of the CCJ decision. The applicant also referred to recital 8 of Order 60, which is quoted. It is submitted on behalf of the CEO that even if Section 22 is constitutional, Order 60 as subsidiary legislation overreaches, as it gives GCOM power to recount votes that have already been declared final pursuant to Section 84 of the RPA. It is urged that GCOM cannot, by subsidiary legislation such as Order 60, give itself the power to resolve elections disputes which are for an election petition. In this regard, GCOM arrogated to itself the authority of an election court by invalidating the declarations. Therefore, Order 60 is unlawful. Reliance was placed on paragraph 52 as well as paragraph 46 of the CCJ decision. The AG submitted that Order 60 created a new regime which is in tension with Article 177(2)(b) and Section 96 of the RPA, which provides for the CEO to ascertain the election's result by calculating the total number of valid votes cast from the declarations of the returning officers. The chairperson and the added respondents submitted that the CCJ did not invalidate Order 60. It is contended that when read as a whole, the CCJ decision confirmed Order 60. Further, it is submitted that the Court of Appeal permitted the recount by its decision in Moore. It is also pointed out that the David case was argued both in the Court of Appeal and on its appeal in Ali at the CCJ on the premise that Order 60 is valid. It is submitted that the CCJ decision is replete with references to Order 60, which are premised on its validity. It is stated that the CCJ has specifically reviewed and approved not just the recount, but the contemplation that the result of the recount will be binding and will be acted upon, and therefore any argument that somehow this recount cannot be used by GCOM is specifically rejected by a court which binds us. As a consequence, it is urged that this issue is also res judicata and cannot be inquired into by this court. I have concluded that an holistic review of the CCJ judgment in Ali supports the contention for the chairperson and the added respondents that this issue is indeed res judicata. Thus, the interpretation of the CCJ decision by the applicant, the CEO, and the Attorney General is hopelessly flawed. The CCJ judgment lends to the ineluctable conclusion that the recount votes are ex facie valid. Hence, the view expressed that any irregularities would have to be addressed via an election petition. Paragraph 37, which is relied on by the applicant, seeks to further explain what the CCJ described in paragraph 36 as a hybrid presidential system. The court explained that an elector's single ballot serves to determine both election of members of the National Assembly and also election of the president. This explanation has to be linked to the consideration of the decision of Justice Reynolds in the Court of Appeal, as referred to in paragraph 15 of the judgment, that Order 60 established a new elections regime in separate elections for members of the National Assembly on the one hand, and on the other hand, the election of the person deemed to be president. Paragraph 37 is clearly linked to a finding that this aspect of the decision of Justice Reynolds was not correct. Significantly, paragraph 37 cannot be read in isolation. This is so because immediately thereafter, in paragraphs 38 and 39, the CCJ explained Order 60 in detail, commencing with the opening statement that, quote, Order 60 relates only to the elections held on 2 March 2020, end quote. Importantly, the court went on to highlight that, quote, it was specifically introduced to cater for the various disputes and contentions that arose after polling day. The intention was to provide an open, transparent, and accountable recount of all the votes cast in those elections. The purpose was to assuage the contestations among the various parties, determine a final credible count, and remove certain difficulties or fill certain gaps in connection with the application of the provisions of the Representation of the People Act, end quote. After noting that the CEO was to supervise the recount process and that the aim at transparency included a variety of measures, in outlining the procedures for the recount as provided for in Order 60, the CCJ emphasized that, quote, Order 60 carefully set out how the process should unfold, end quote. And then I quote from paragraph 39 of the judgment. It is in this context that paragraphs 45 and 46 of the CCJ judgment have to be read. Therefore, the applicant's view that the letters from the chairperson to the CEO are invalid because they require him to produce a report based on the valid votes of the recount, which conflicts with the CCJ's explanation of valid votes in paragraph 45, has no merit. Indeed, in my view, this claim is another way of putting the claim made by Ms. David, which is recounted at paragraph 14 of the CCJ judgment, that, quote, the chairperson's 16 June directive to the CEO, who by Section 18 of the Election Laws Amendment Act 2000 is mandated to be subject to the direction and control of the Commission, require the CEO to commit an illegality, end quote. This is in the context that the June 16, 2020 letter, as quoted at paragraph 8 of the judgment, also requested the CEO to produce an Article 177(2)(b) and Section 96 report based on the results of the recount. In all this, the CCJ clearly considered the allegations made by Mr. Harman, an election agent for the APNU AFC, as regards irregularities, voter impersonation, and fraud, and noted the concerns expressed by the CEO, commenting that he took it upon himself to present revised totals. I consider that this prompted the CCJ to make the comments or the findings that it did in paragraphs 40 and 41 of the judgment, which I quote. Therefore, which I have quoted, sorry. Therefore, far from nullifying Order 60 and the recount process, in my view, the CCJ explicitly endorsed it. It is clear from the above quoted part of paragraph 39 that the court was stating how the CEO was to conduct the tabulation, how he was to prepare his report for transmission to GCOM for its deliberation, and importantly, that such report would determine whether it would request the CEO to use the data compiled as the basis for the submission of a report under Section 96 of the Representation of the People Act. As regards paragraph 52, the CCJ, in my view, was simply saying that a subsidiary legislation, Order 60, could not be used to interpret the Constitution as the Court of Appeal had ruled, and that where there was tension or possible conflict between the subsidiary legislation and the Constitution, the latter would inform an interpretation of the former and not vice versa. The CCJ re-emphasized that Order 60 did not and could not create a new election regime. This was a clear reference to its finding as regards the decision of Justice Reynolds. The court did not, in explaining how any tension between the Constitution and subsidiary legislation should be treated, negate or nullify Order 60 either expressly or impliedly. And there is another reason why the applicant's contentions in relation to the recount cannot be upheld. In Moore, the Court of Appeal clearly stated that this would be an issue for a petition. The court concluded this in paragraphs 85 and 86 in relation to the recount, and I have quoted these paragraphs. And at paragraph 88, it was stated that, quote, whether the proposed recount is lawful are matters which would fall for determination under Article 163 of the Constitution, end quote. The fact that the Court of Appeal referred to the recount as proposed at the time does not negate from their decision as to what was to happen if one were dissatisfied with the recount. The completion of the recount cannot change this holding of the court. The Court of Appeal had before it the issue of the unconstitutionality of Section 22 and the recount. The Court of Appeal, in determining that it was, quote, in a position to exercise jurisdiction in its own right and to make orders it considers appropriate to dispose of the appeal, end quote, did not grant the injunction sought to prevent the recount. In effect, the Court of Appeal permitted the recount to proceed with the caution that it must be a GCOM-controlled process. Then at paragraph 89 in Moore, the Court of Appeal went on to say that, quote, an election petition which has the features of a trial or court according to the procedures set out in the National Assembly Validity of Elections Act and rules, would be the place for controversy central to the elections to be resolved by the High Court by way of evidence and cross-examination of witnesses. In that process, the court can also consider constitutional questions as part of its determination of any disputes before it, end quote. The evidence in this case at bar, as does the evidence as it appears from the judgment in Moore, reveals that there were and still are matters to be addressed by GCOM which relate to the execution of its functions under Article 177 and Section 99 of the RPA. The evidence, as in Moore, also reveals conflicts on issues that have to be addressed by GCOM. Hence, the conclusions of the Court of Appeal at paragraphs 85 and 86 of their judgment, as confirmed in the conclusion at paragraph 109. The affidavits in the case at bar clearly demonstrate that there are still matters in controversy. Thus, both courts by which I am bound have pronounced on this issue. This court, therefore, cannot rule that Order 60 is invalidated. This issue is therefore res judicata. The fourth issue, whether the declarations of the returning officers for the 10 electoral districts made pursuant to Section 84 of the Representation of the People Act, Chapter 103, should be acted on or be set aside. The applicant in her affidavit spoke to this issue in support of her contention that there must be reliance in the declarations of the returning officers at paragraphs 50, 51, and 54, which I have quoted. In light of her affidavit, it is submitted that the declarations of the returning officers for the 10 electoral districts, having been submitted pursuant to Section 84, they cannot be discarded and replaced. Thus, Order 60 could not permit new declarations. If it did, this was unconstitutional, as this order encroached on the jurisdiction of an election court under Article 163. The order also breached the RPA because the returning officers, as statutory officers, were excluded from the recount process. The latter assertion is an evidential issue that may be in controversy, and I do not rely on it. It is further advanced that Order 60 could not have retrospective effect, so as to nullify the Section 84 declarations made by the returning officers. The submissions continued that the returning officers were mandated to issue their directions pursuant to Section 84 of the RPA. Then the CEO was to consider them and prepare a report for GCOM pursuant to Section 96 of the said Act. These submissions were supported by those made on behalf of the CEO. It is submitted that Order 60, as held by the CCJ in Ali, could not institute a new legal regime for the declaration of the votes. Thus, the RPA had to be complied with, as Order 60 could not replace the requirements of this Act. Order 60 established a new regime for the determination of the validity of the votes by persons not authorized to do so. It was submitted on behalf of the CEO that Order 60 amended Section 84 by replacing the declarations with the recount as the source of the result. The AG submitted that the nullification of the 10 declarations can only be done by way of election petition, and he relied on paragraph 46 of the CCJ decision in Ali. My conclusions as regards the interpretation of the CCJ decision regarding Order 60 necessarily mean that the answer to this issue is that the declarations of the returning officers as made pursuant to Section 84 have been overtaken by events whereby GCOM, in its wisdom, considered that there were difficulties that had to be addressed in order to produce what is termed in Order 60 as a credible count. In this regard, difficulties have arisen subsequent to the declarations made, and Order 60 was meant to address them, and in this regard cannot be said to have retrospective effect. As noted by the Court of Appeal at paragraph 109 of Moore, it is within GCOM's functions to resolve those controversies as part of its responsibilities to deliver results of the elections. As noted earlier, the CCJ stated in paragraph 38 of Ali that the intention of Order 60 was to provide an open, transparent, and accountable recount of all the votes cast in those elections, end quote. It is in this context that Section 18 of the Elections Laws Amendment Act has to be read. This section states, I quote, "The Chief Election Officer shall, notwithstanding anything in any written law, be subject to the direction and control of the Commission." The fact remains that the circumstances surrounding the declaration of the results of the March 2, 2020 elections are contextual. As just concluded, given the decisions of the Court of Appeal and the CCJ, the recount cannot be considered to be invalidated, at least not at this point in time. In this context, the Section 84.1 declarations can no longer be considered useful. Hence, while the CEO may be expected to act independently, he cannot be a lone ranger, so to speak. I agree with the submission that Article 172(2)(b) can be construed to mean that GCOM is not to act on the advice of any person or body external to the Commission. I do not agree with the submission that the CEO has a constitutional mandate under Article 177(2)(b). It is the chairperson and GCOM that have the constitutional mandate. The CEO is a functionary of GCOM pursuant to Article 161A and Sections 2 and 7 of the RPA. Section 18, which is repeated in Order 60, merely confirms this, and the obvious for the avoidance of doubt that the CEO cannot act on his own. In this regard, he has certain duties as regards tabulating results as provided for in Section 96 of the RPA. Section 18 is therefore not unconstitutional as being in conflict or in tension with Article 177. And as noted earlier, the CCJ also stated in paragraph 41 that any allegations as alluded to by the CEO can be addressed by way of election petition. If it is the considered opinion of the CEO that in the face of Order 60, he can produce a report based on the Section 84 declarations, then one would expect that he must be guided accordingly by GCOM. This, the evidence discloses, the chairperson has sought to do via the letters transmitted to the CEO. Thus, as determined by the CCJ, unless overturned by a court in an election petition, the only data that could be used for the declaration of the results of the elections would have to be the recount results or data. For the reasons outlined, the 10 declarations cannot be resurrected at this point in time. In this regard, there can no longer be an impasse between the chairperson and the CEO as to the effect of Article 177 2B and Section 96. For the avoidance of doubt, as stated in Section 18, the CEO is subject to the direction and control of the Commission. In this regard, I refer to paragraph 14 of the CCJ judgment, where it is noted that by Section 18, the CEO is, quote, mandated to be subject to the direction and control of the Commission. Now to the final issue, whether these issues are res judicata, given the decisions of the Court of Appeal in Moore and of the CCJ in Ali. In light of the discussion above, the decisions of the Court of Appeal and the CCJ have guided me in answering the issues that have arisen as a consequence of the 28 claims for relief sought by the applicant. Apart from Section 22, which was specifically cited, there are a number of the reliefs claimed in this application which were claimed in or mirrored in the claims in Moore and which I consider cannot be relitigated. Some of these were highlighted in the submissions for the 10th added respondent. It can be seen that the relief sought at Roman 5 and 6 in this application replicate those in Roman 4 and 6 of Moore. Paragraph 19 is exactly the same as paragraph 7. Paragraph 20 is mirrored in paragraph 9. Paragraph 21 is seen in paragraph 10. And paragraph 23 is similar to paragraph 11. Indeed, although couched in different terms, this application for the most part mirrors that in Moore, and in effect is similar to that of Ms. David in the Ali case. Res judicata is a legal principle that speaks to ensuring finality in litigation. As explained in Halsbury's Laws 5th edition, volume 12, Civil Procedure, at paragraph 1168 et seq. The doctrine of res judicata applies where a matter has been adjudicated on by a competent court so that the matter cannot be relitigated. The principle can take different forms: estoppel by record, cause of action estoppel, and issue estoppel. Importantly, as submitted by the chairperson and added respondents, one has to consider that this application and that in Moore, as well as Holidar before them, are public interest litigation. Thus, such cases do not fall into the traditional criteria required to determine whether res judicata applies. The traditional formulation was confirmed by the CCJ in Garraway and Williams. Public interest litigation affects the public at large. While it has to be instituted by a person, the litigation should not be considered to be in personam or between or determining the rights of the parties thereto. It should be considered to be in rem, that is, leading to a determination of the status of a person or thing, or the disposition of a thing as distinct from a particular interest in it of a party to the litigation. And importantly, as highlighted in the submissions, the CEO was a party in Moore, Ali, and is a party in this case. Whether he participated in the proceedings or not, he is bound by the decisions in Moore and Ali. Also in Halsbury's Laws 5th edition at volume 12 at paragraph 1182, the extent to which issue estoppel can apply to public law proceedings is discussed, though the context of the learning suggests its application may be limited. In my view, and I so hold, where there is public interest litigation, such as this application, barring a new issue arising or one that can be distinguished, or a claim that the judgment was improperly obtained, for example, through a misrepresentation of facts or law, or the perpetration of a fraud on the court, an applicant is bound by the decision on any issue that has been raised and adjudicated on previously. There must be finality to judicial decisions. Myriad persons cannot be permitted to engage with multiple applications regarding the same issue which has been decided and shield behind the claim that they were not a party to the previous proceedings. To so permit would be to waste precious judicial time and resources. In short order, this cannot be allowed. Rahman, the Chief Elections Officer, FDA 1151 of 2019 was a public interest litigation case, which required an interpretation of the CCJ decision in the consolidated appeals of Rahman, the Attorney General, Jabdion, the Attorney General, and Passard and in holding that the CCJ did not make an order that referred to or included a date or period for the holding of elections following the successful no confidence motion. As such, apart from applying the doctrine of stare decisis, I concluded that res judicata applied to the claim by Mr. Ram, and he was bound to the decision of the CCJ in this. Take precedence over this court. Apart from res judicata, under the common law system, applying the principle of stare decisis, I am bound to follow the decisions of the Court of Appeal and ultimately the apex court, the CCJ. The application is accordingly dismissed. I have been lenient in the award of costs in what I call national interest matters, since I have considered them important for the development of our jurisprudence, more especially our constitutional jurisprudence. However, on this occasion, having found that the issues have led to a determination, having found that the issues that have led to a determination of this case have been decided by superior courts, the issue of costs has to be addressed differently. So unless council agree to costs, I will invite submissions on costs to be filed and served by all parties by email on or before July the 24th, 2020 for issuance of a cost order thereafter. That is the judgment of the court.
Much obliged, Your Honor.
Good for you, Honor.
Thank you very much, Your Honor.
May it please, Your Honor. May it please, Your Honor.
Sorry, yes, Mr. Ford.
Thank you, Your Honor. Your Honor, we are grateful for your decision, Your Honor, and your time and your legal expertise that is reflected in the judgment. Your Honor, would, as you've said in your closing remarks, Your Honor, that this case and the issues raise substantial issues of constitutional importance and of importance to the nation as a whole. In the circumstances, Your Honor, whilst we are not required to seek the court's leave to appeal to the Court of Appeal under Article 133, Your Honor, we wish to inform the court and the parties that we intend to so file an appeal to the Court of Appeal. Your Honor, at the commencement of the matter, I believe the Chief Elections officer and the chairman had given undertakings not to act in any way that would affect the outcome of Your Honor's decision or to affect the issues as far as I recall. I may not have gotten it precisely correct because sometimes the signal goes and comes, Your Honor. But substantially, Your Honor, I'm asking that the two respondents that I refer to, the Chief Elections Officer and the Chairman of the Elections Commission, do have their undertakings continued, until the hearing and determination of the appeal to the Court of Appeal, and by way of further information for consideration, Your Honor, we intend to file the appeal no later than the end of tomorrow, Your Honor.
Well, I don't know what Ms. Kite has to say on this issue. The CEO gave no undertaking, Mr. Ford. It was Ms. Kite who gave that undertaking on behalf of the chairperson of GCOM.
If I may, Devendra Kisoon, perhaps the issue of a stay would be better canvassed upon the filing of an appeal. And without an appeal being before the court, it's very difficult for any party to engage in any discussion concerning a stay. And I'm certain...
Mr. Kisoon, I know that Mr. Ford did not ask for a stay. At least I'm not reading it that way. He is asking for undertakings to be given by, at least that's how I'm understanding him. He is asking for undertakings to be given by the CEO,
She can give it.
the chairperson. I was indicating to the chair that the CEO did not give any undertaking in this matter. It was only the chairperson who did.
Certainly, Your Honor. All I'm suggesting is perhaps that consideration would be better suited upon the filing of the appeal.
Please, Your Honor, might I support the application by Mr. Ford, if only for the fact that it has been the established practice of the chairman of GCOM that once we have indicated clearly that we intend to see it in relation to issues that are germane for the entire country, perhaps for the future of this country, that the court will say, "Sir,
Jared.
There we have it, Randy. For those persons who might have been hoping, Randy, for those persons who might have been hoping that the Chief Justice in these election cases might have ruled differently this morning, those hopes were not realized. But as Mr. Ford, Senior Counsel Royal Ford, Member of Parliament, has indicated to the Supreme Court, or the High Court as we know it, that they intend to appeal this matter to the Court of Appeal.
Yeah, definitely. Senior Counsel Ford indicating that an appeal will be submitted no later than the end of tomorrow. So looking forward to that. Sherrod, disappointing as you said, the Chief Justice ruling that, you know, many of the litigations there deemed res judicata. So and has basically dismissed the appeal, not the appeal or the petition in the court. Of course, there is scope for an appeal, and we look forward to that. So now we have both petitions will be appealed in the appeal court. As you said, Sherrod, persons who are hoping for a different decision would have been disappointed. But you would have said before we came on air that, look, this matter will eventually see it resolve it at the CCJ.
Yeah, and you know, it was the Chief Justice, and I want to follow in the tenor and tone of Senior Counsel Royce Ford, who thanked the Chief Justice for her judgment. He spoke about how it was an expert judgment, and thorough. Um, just before he would have asked, well, rather before he would have notified the court of the intention of the petitioner to file an appeal. And so I want to follow in that same notion that either way, on that same tenor, that either way, whichever way this case would have gone, would have seen us go before the Court of Appeal locally and perhaps ultimately to the CCJ. We did see quite recently the Chief Justice rule, for instance, that Minister of Tourism, was sitting in Parliament illegally, having being a dual citizen. We did see her rule that 2 parliamentary secretaries were again illegal in National Assembly. But on the substantive election petitions ruling, she has held a line where those rulings are concerned. And I want to leave the dissecting really for the legal experts as they come in a couple of minutes to give us some reactions.
Sharon, I know also that we're having problems with the outside field. I know that the leader of the opposition is at the court and he was making a few statements. We're hoping that we can get him on the show in not so distant future, so he can give his reactions here, because we would have missed that owing to that breaking transmission there on the ground. But I know he's out there right now, and he would have addressed the crowd out there, those persons who are wondering. Also, as you said, we're hoping to get Mr. Royce Ford and the other legal minds to come and unpack the legal ramifications of what would have taken place this morning.
Yeah, but I would say at this point, if anybody wants a very thorough rehearsal of the history of what has brought us to this election petition from March 2nd to now, that this is a judgment worth re-listening to and rereading when it is made available in hard or soft copy format. Because if everything else aside, the quality of the judgment aside, the Chief Justice really and truly walked us through from March 2nd, highlighting all of the significant signposts that has brought us to this day, the 26th day of April, and the kind of ruling that she would have handed up.
Yeah, definitely. And and it will be interesting to hear what how the senior counsel will go about in terms of appealing it, and the arguments there also. Also, I am interested, as we talk about these cases, I'm extremely interested in Petition 99 and where that goes. My own personal opinion about the strength of Petition 99, I believe that no court would be remiss to hear all of those evidence, and go through all the evidence of the anomalies and the irregularities, and come down on the side and say, you know what, the elections were credible. So I think, I'm extremely interested in to hear that appeal of Petition 99.
Lloyd,
Yes.
Randy, my own legal learning is not as sharp, but I think I heard consistently the Chief Justice was saying, the Chief Justice Roxanne George Wiltshire was saying that lots of the issues were res judicata, meaning that they were already decided in the Superior Court, and that she could not go against those rulings. So a Superior Court, like for instance, the Court of Appeal or the CCJ, could look at this whole issue differently. But I think substantively, I kept hearing her saying that matters were res judicata, which means that she could not go against the ruling of a Superior Court, since they were already they were canvassed in a Superior Court and decided on. And so it'll be interesting to see, as you said, how we move forward. But we know, Randy, that either way, this matter was going to the CCJ the very same way the matter of the parliamentary secretaries, which the government just lost before the exact same Chief Justice, Roxanne George Wiltshire. They have already signaled to the court that they're taking that matter to the CCJ. So we would have already spelled it, and we see again that either way this matter would have gone, would have seen it go before the Court of Appeal and perhaps ultimately the CCJ.
Yeah. I don't know if you got the live feed is back from on the ground there. I don't know what is happening on that
No, the
end.
quality, I'm seeing it here, but the quality isn't any better,
Okay, it's still sticky.
unfortunately.
We're still having
Unfortunately,
problems with that.
but on petition 99, Randy, as you brought it up, that appeal comes up for hearing on June 14th. I just want persons who are
Yes.
interested in that to probably make a note on their judicial calendars. June 14th, it comes up for hearing, and you know it was from some of the cases that came before the High Court during this election process, which the Chief Justice graciously outlined. We kept hearing the reference to these are matters for an election petition. These are matters for an election petition. And now they were brought. We know already, Randy, from 99, that case has not been decided on the substantive issue, but basically on a technicality, which can be used. Former President, His Excellency David Arthur Granger, was not properly served in that case. And it's on that basis, that kind of technicality, that caused the case to be knocked out in the first place.
Sharon, I want to sort of clean up a bit of what you're discussing there, this idea of service, and why petition 99 was thrown out. It was my understanding on the issue of service, there was a mistake made on the service papers to David Granger, where one date was written and it was actually served on another date, right? So the date that was written on it was outside of the actual time frame in which it was supposed to be filed, which was a mistake by the two young people at the courts, and to which they would have submitted affidavit saying, look, listen, this was a mistake. Unfortunately, those affidavits were not considered, and the Chief Justice relied on this strict rule that the document needed to be served within this time frame, and they essentially said that, look, she does not accept the explanation that it was a mistake. From some legal minds, Sherrod, have said that is a cheap way to throw out such an important matter of national importance. A matter of national importance was thrown out on such a cheap note, and also would have said that, look, the court has ways of remedying such a situation, and there is precedence where you can count on or you can call on where the courts would have remedied situations like this in lesser matters. So I am sort of confident that when this is adjudicated at the Court of Appeal or CCJ, that this matter on the grounds of which petition 99 was thrown out will be reversed essentially, and substantive evidence will be argued. The substantial evidence will be argued in that case.
Yeah, and that's as you mentioned, Randy, and as said by the Chief Justice, Roxanne George Wilshire, that this matter is one of tremendous public and national interest. And so it will be interesting to see that if you go along with the Chief Justice ruling here this afternoon, which just concluded, started around 11. I didn't expect the ruling to be so long, but she walked us through for about an hour and 15 minutes of, as Senior Counsel Roy Ford said, a very, very expert ruling. But it'll be interesting to see whether the recount order 60 is valid, whether Section 22 of the Representation of People Act is valid, and all of that. One would want to see now the issues which arose out of the recount itself, because those issues have not been dealt with substantively, which are housed and composed in election petition 99. None of those substantive issues of the impersonation and the dead voting and all of that, the missing poll books, the ballots, ballots were invalidated, as well as ballots were validated through that recount process. So none of those substantive issues really and truly have been dealt with, because again, as we've been articulating here, that petition 99, which deals with those issues, was struck out because of this technicality of have not been properly served, at least in the impression of the Chief Justice.
Yeah, and interesting, when that time comes, there's no reliance on this argument of res judicata, because these are matters that are fresh, so to speak. But we'll deal with that at that point in time. As you said, June the 14th, we'll hear those arguments in the appeal of Petition 99. And of course, we're expecting a swift appeal of this particular petition that was thrown out today, dismissed today. As we would have continued to say, folks, as we would have continued to say, at the end of the day, these matters, it is almost shared as if, going through our lower courts is academic. It is just a procedural thing nowadays. And that when the matter actually reaches the apex court, that is when you have any consequence, so to speak,
Yeah.
because at the end of the day,
Yeah.
with any side, the judgment would have come down today. Any side, the opposite side would have appealed, and then
Yeah.
at that point in time, that we will then push on to the CCJ. So do not despair, as we always tell you. We'll continue to hold the line of battle. We believe that at the end of the day, whether it's petition 88 or petition 99, right, the courts will come down on the side of the law, and that is the hope. And again, and as we say, the sheriff, it is a dangerous game to speak in a manner that erodes the public trust in the court and the judicial system.
Yeah,
Because
as Randy, as one engages in politics, and especially as one engages in these court matters, I would say you have to pace yourselves because, for instance, just like how we are grateful for the ruling of the Chief Justice in the Parliamentary Secretary's case, that case could similarly be overturned by the Court of Appeal, a superior court, and similarly, as the Chief Justice has ruled in 99, setting that position aside, and ruling this one, 88, petition 88, the Court of Appeal and ultimately the CCJ, the Criminal Court of Justice, could also rule differently. And so, this isn't over until the big court sings, as it were.
Exactly. And it speaks to that same thing you're talking about pacing yourself and not to, speak in a manner that would erode the public confidence in the court, because at the end of the day, the courts are there and it serves everyone, right? Like you said, there was a ruling recently by the same Chief Justice that came down on the side of the APNU AFC, right? So at the end of the day, you have to balance your displeasure and disappointment with a healthy dose of respect for the judicial system and the role it plays in our country. And we know, of course, that there are steps that we take. So we move to the appeals court and then we move to the CCG.
And Randy, I want to elaborate on that last note there of the importance that these cases play, because that is what particularly the Chief Justice ended her delivery of this judgment on, by saying that yes, these matters are of public importance, but she went on to talk about the judicial importance of it expanding our legal learning, our legal knowledge, or what we call the jurisprudence, the constitutional jurisprudence or electoral jurisprudence, because we have always had these question marks over particular pieces of legislation, whether they were constitutional or not. But unless those things are brought before the court and you have a declaration, you have a decision on them, then you just don't know, right? And so a lot of what was law is now really and truly being either reinforced or struck out.
Tested. Yes, the interpretation of it.
Largely tested.
Yeah, I think that's an important point. The court is there to interpret, right? These laws are there, and many men and women, so to speak, I use men generally there, have argued over the interpretation of a particular law or a particular legislation, but only when this has been litigated over and argued over in our courts. This is the role the courts play, all right? Whether it be the lower courts or the higher courts. Only then, when a judgment is actually, an opinion is actually passed down, then we can say, okay, we can lean on this particular issue, this particular ruling, as the final interpretation of this particular law. And as you said, adds to the body of the jurisprudence.
Yeah,
very important.
Randy, as Senior Counsel Royal Ford said at another forum, for those persons who are now catching up with Elections Petition 88 and 99, he would have said that Elections Petition 88 represents, or challenged GCOM that it did not have the power to conduct the recount and or the constitutionality to conduct the recount, and 99 focused on the credibility of the recount process. 99 focused on the credibility of the recount process, and the 88 focused on whether or not GCOM had the power to conduct the recount. So I think that, in a very simple way, outlines what Election Petition 88 and 99 is about for persons who might be viewing for perhaps the first time or now catching up, giving context to what we're discussing.
Yeah. And as you're reading that, you're getting word that we are going to be joined by the leader of the opposition. He's going to read a statement. So those persons who are still on the live, thank you very much. We hope that you continue to share because, it's important information being shared here. And we are going to be joined by the leader of the opposition in just a few minutes as he responds to this decision. Sharon?
Yeah, and it's important. So, and we're going to have some commentary after that. But to hear in a broader context, where do we go from here? We've already heard Senior Counsel Royal Ford intimate to the court that we are pursuing an appeal to this matter. No prejudice to the Chief Justice decision, which he called an expert decision, after thanking her, for sitting for more than an hour and 20 minutes and delivering this judgment. And folks, this is not only relevant to us here in Guyana. It's important for us to get it right. Caribbean jurisdictions are going to be impacted by this. How elections, petitions are held, the sequence of events, subsidiary legislation in relation to, main pieces of legislations, how those things interact with each other, the role of, chief elections officers, the role of election commission chairmen and women. So a lot of what was in the books, as we said earlier on, it's now really and truly being litigated. We have lots of laws on the book, but the constitutionality, the legality of lots of it is being litigated. And this is going to impact Caribbean jurisprudence, Commonwealth jurisprudence, because as we say, this matter is going to the CCJ one way or the other.
Yeah, definitely. And I mean, we have shared from March 2nd to now. We have gone through, so many of these court cases, and we see them over and over. Some positive, some come down on the other side. It all adds to, as you said, to the jurisprudence. But more importantly, we must understand that our court systems, in the way that they are currently set up, has to work out and play out like this. It has to, because both sides have the right to appeal, both sides have the right to take cases to court, and it has to play out as it is right now. So as we're seeing this, we're talking to especially those persons who may be a little disappointed today. Do not despair. The court systems are set up in such a manner that there is scope to appeal, and that will be done. Both petitions are still alive. They are in the court system. And Sharon, I wanted to share a video with you. I was trying to get it. I'll see if I get it before the end of the show, where Amanza Walton Desir, MP Amanza Walton Desir, spoke very eloquently about how we got to this position of elections petition, and the fact that the facts are there, the evidence are there. You can try as much as you want to throw them out and use all the tricks in the book, but the fact remains that you have not proven to anyone that these fraudulent things that were discovered during the recount are not so. That is the reality. And that, as we continue to say, unless these petitions are heard, especially petition 99, unless that is heard in a court of law and the evidence comes out in front of a judge or judges, then the PPP will always have this shadow over their heads, dragging behind them like a bad habit, dragging behind them, clouding their tenure in office as fraudulent.
Yeah, and Randy, it is on this particular note. That is why I said, even with the legality of Order 60, as
Yeah.
articulated by the Chief Justice, even with the legality of Section 22 of the Representation of the People Act, what remains is that those ballot boxes were opened, right? And we peered into them as a nation, and we did not like what we saw collectively, and
Yes.
that would still, as you rightfully said, be hanging over the Damocles sword, as it was, hanging over the necks of the installed PPPC administration.
Right. Just a reminder that we will be joined by the leader of the opposition in just a few moments. As they said up there, he will be reading a statement in response to the ruling this morning. Again, people, it was articulated by the senior counsel Ford that this petition will be appealed, and an appeal will be submitted to the court no later than tomorrow. So if you're on the live, just stay tuned. We will be hearing from the leader of the opposition, who made a statement outside of the court just now, but he's going to be joining our show to bring that directly to you. Jared.
Yeah, and
Go
ready,
ahead, no, go
Randy,
ahead. No. I'm saying, as a Guyanese, I would, putting myself in the place of the PPP at this moment, it seems as though they are extremely comfortable sitting in the seat of power, knowing that this cloud of fraud is hanging over them, and will do their darndest to try and not let petition, especially petition 99, which
Yeah.
when it actually is heard, we'll see hundreds of witnesses take the stand, thousands of pieces of documents reviewed,
Yeah.
which paints a very damning picture of fraud in the elections.
Yeah,
And again,
and those yeah.
Go ahead.
No, and those things, Randy, as you mentioned, documents, because I did say, when we opened the boxes during the recount, we did see missing certificates of employment. We did see, persons who would have been deceased prior to March 2nd, who miraculously would have casted a vote. I was in Burbis quite recently, and one gentleman from the Bad Settlement area, he called out names that are overseas who he saw ticked off as having voted. Persons who he know are dead in his community, who he saw as having voted. So we have to deal with that. Those dead persons who would have voted, persons who would have migrated and would have voted. And if persons remember the Chief Elections Officer, Mr. Keith Lowenfield's report to GCOM, the very first paragraph dealt with these two substantive issues: dead persons who voted and migrants who would have miraculously voted, persons who would have voted without ID cards, persons who would have voted without oaths of identity, unverifiable oaths of identity due to missing poll books, unstamped ballots, missing poll books, missing official list of electors. Every polling place should have its official list of electors in the ballot boxes where they tick off those persons as they come to vote. Missing official list of electors. You have, so it was a series of things that the same Order 60, which the Chief Justice is contending is legal, which spelled out this scrutinizing process of the votes during the recount and what should be done. And yes, votes were accepted as being valid, that did not satisfy the very scrutinizing process that was articulated by Order 60.
Yeah, definitely, Sharon. And I mean, I was listening to Mr. Henry Jeffrey, former PVP minister Henry Jeffrey, speaking on a show recently. I think it was David Hines Politics 101, and he was apoplectic. He was apoplectic in his response to what happened on March 2nd. He said, never before in our history were we able to see the evidence of fraud like this. And he spoke of the seriousness of having the CEO in his report saying that, look, this thing can't be deemed credible. And the scant disregard of the CEO's report, the fact that you undertook to disregard the CEO's report is what was, so strange. The person in charge of running the elections, you basically said, look, we're not going to worry with what you say. The recount revealed that the numbers couldn't be deemed credible. And as I said, Sharon, I think we have a video here that you can probably show, which is Amanza Walton Desir on the Bransford Burke show. And I want you to play it. It's just, I think, a minute, speaking about what those facts are as we wait on the leader of the opposition.
Great, Randy.
Yeah. I think you have to play the video. Yeah. So
I'm getting some challenges at my end. Yeah.
Okay. Well, that is the video where she was very articulate in talking about this shadow that will continue to follow the PVP.
So we're not in the realm of supposition anymore. We know for a fact that people have voted. We know for a fact that people who are not in the jurisdiction would have voted. We know for a fact that there are 47 ballot boxes without documents. These are facts that are incontrovertible. It's not up for debate. We're not unsure about these things. And so I think the only reason that we ended up at a petition was that the court recognized that while everybody in fact recognized that whilst we have discovered these anomalies and irregularities, the mechanism through which we could address them is an elections petition. So it does not negate the fact of the findings. It does not negate the fact that the PPP has not been able to refute these allegations. And so even with this throwing out of the petition, temporarily I would say, because I believe we have very, very strong prospects in terms of appeal, the PPP has not convinced anybody that they have not gotten there by illegitimate means. Because the very mechanism through which we were going to receive, as it were, the imprimatur of the court to say that these actions were illegal, it is the same mechanism through which the PPP could have acquitted themselves of these charges. And so these facts remain, and this is what I want to encourage our people. Don't be disheartened by this. The facts are the facts.
Yeah, Sharon. Very, very eloquently put there by Amanza, Sharon. Yeah. I think your microphone is off, but I'm saying very eloquently put there by Amanza, which says to people, look, listen, the facts are the facts. And the PVP can try to run as much as possible, but at the end of the day, these matters will eventually be heard in the court. Go ahead.
Correct. And you said early on, Randy, talking about Dr. Henry Jeffrey in his own statement. One of the things that I'm trying to reconcile in my own mind is all that has been said about GCOM and its powers. And I heard some of it being articulated again by the Chief Justice, in which they say about GCOM having wide and omnibus powers to make decisions that are in its interest of that are in the interest of justice and impartiality and expediency. And the Chief Justice herself, this Justice afternoon, talking about how GCOM is vested. I've heard the current Attorney General talk about the huge plenitude of powers vested in GCOM to do almost anything that is relevant, fair, and necessary to bring a fair and smooth conclusion to the elections. And again, I heard the Chief Justice talk about this, about GCOM having the power to make decisions that bring the election to a finality, right? But all of this seems to be decision only that projects results in a particular direction. Because, for instance, when it came to just simply writing and finding out from the Commissioner of Police whether these persons on this list would have been out of their jurisdiction on March 2nd, the TCOM chair didn't seem to have the power to do that. These omnibus powers, these plenitude of power to resolve its internal conflicts didn't seem to extend there. To write to the general registrar to find out whether these lists of persons would have been dead prior to March 2nd, but miraculously voted based on the fact that somebody would have ticked off their names on a list, right? And votes casted in there said what is termed in electoral terms as impersonation. You know, all of these powers of GCOM to resolve its own internal issues didn't seem to extend there. And, you know, GCOM's ability to do simple investigations to, again, resolve conflicts during the electoral process didn't seem to extend to anything that basically that was brought by the then APNU AFC administration to GCOM to be resolved. It didn't seem to have any of those powers.
Yeah. You know, you know, we
that is the contradiction.
That's a contradiction. But you know, as we wait on the leader of the opposition, they're setting up over there to bring him in, and we want to ensure that everything is okay as he comes in. I wonder if you could permit me, Cheryl, read some of the comments from persons who are responding online. Those persons are on the chat. We want to thank you for your participation in this live broadcast, and we hope that you continue to comment your reactions. You know, some of them
share the live stream as well.
And share the live stream, but some of them are a little controversial. But we're going to read it because we want to get a sense of how those persons who are on the outside looking in, how they feel about this particular issue. Bernard Innes shared his thoughts. He said, "This soft-foot attitude on the part of our leaders need to stop talking and advocate for total shutdown of the country." Right? That is a particular point of view shared by a number of persons. In that, you know, they're advocating for harder actions. But as I normally say, there's a place for that and there's a time for that. There's a place and there's a time for that.
Randy, I hope Bernard is one of the persons on the ground right now in front of the high courts. I hope so.
Well, yes, I hope so. Right? If Bernard is listening, you let us know if you are there and you're ready for action as you're advocating here. But again, I will only say that there's a time for that. Let us, because at the end of the day, Shared, we know that these two petitions are in the court. It's at that second level right now. It is going to eventually meet to the final, the apex level, which is the CCJ. And let us keep our fingers crossed and do not despair, because the evidence is on our side, right? Ms. Daniels wants to know, when is that time? As people respond on the live chat, when is that time? I will only say I can't respond to the question as to when is the time, but I will say that the petitions have to run their race. If I can put it like that.
Run the course. It's like,
yes, let the petition run the course.
Yeah. It's medication for this electoral ailment of 2020, and they have to run their course.
Yes. Let the petitions run their course. And, you know, at the end of that race, and then a different determination will have to be made, right? But we are hoping, of course, and we have seen in all fairness, we have seen the courts act in a swift and
that is to be commended.
Right, very commendable. The speed at which these petition cases are being heard is, for, you know, lack of a better word, unheard of. Around the world, we know that these cases normally take time, but we commend the court for the speed, right? Somebody else is asking, will the CCJ hear both petitions? The answer is potentially yes. Potentially yes. Both petition cases will eventually end up at the CCJ, and as I am advocating, look, let them run their courses. We have seen them play out in a very swift manner. So there is all hope and belief that they will continue to play out in this manner as the courts act with quite a great amount of alacrity, I must say. I must say that as we continue to hold Sherrod for the lead of the opposition.
Yeah, and Randy, again, that is to the Chief Justice credit. Whether her thought process is eventually proved right and correct by the CCJ when these scores get to that point, would it's going to speak for itself. But from it, it seems to be very, very thorough in terms of the work that was put in. And again, following on what Royce Ford said, Senior Counsel Ford, that he found that it was an expert decision. And
though he disagrees.
Yes, yes. Yes, the quality of the decision, the quality of the decision, even though we disagree with it, even though he disagrees with it, he did find, pause to commend the Chief Justice.
Yeah, definitely. I'm interested to hear the response of the opposition. I've been saying to many persons over the months on my show, the Rush, that it is prudent for us to understand that this is not a sprint and that it's a marathon. Though right now this marathon is being run at a world record pace, I must say. It may seem as if you're in a sprint. Sometimes you're in races with persons who of higher caliber than yourself, and it's a 1500 meter, and they're running like if it's a 400. So
I'll run you a race.
these elections petitions have been moving at world record speeds. So
that is why I said, and we always say, Randy, that don't just hold on to what we say, but try to get as much information as possible, and on these matters or any matter that allows you to make an informed decision, or allow you to make informed decisions, or even to ventilate on these issues yourself in the public domain. And that is why I commend, even though like Senior Counsel Royce Ford, I would disagree with the Chief Justice outcome, the outcome that she arrived at, having looked at information, that her summation of how we got to today's judgment is good reading.
Yes.
The summation of how we got in terms of chronicling the cases and the issues is good reading for those persons who want to bring themselves up to speed, or to look back and to listen at the judgment delivered by the Chief Justice.
Yeah. So another person is commenting here. So why they threw out one petition? The first petition, of course, just to bring persons up to speed, because we know we might have persons who are now joining and who wouldn't have been keeping the breast with what is happening. The first petition, as we said, was thrown out on a technicality on service. The date written on the service or the document served to Mr. Granger was outside the date, the time specified that it should be served, and it was deemed to be a mistake. And even though the affidavit sought to explain the mistake, the judge did not accept that, and she threw that out on that technicality. That particular case deals with all of the evidence of fraud that was uncovered. All of the evidence of fraud that was uncovered. The other case that was dismissed today deals specifically with law. This is opinion. Both sides presented their arguments for support of and or not in support of Order 60, so to speak, arguing against the constitutionality and for the constitutionality of Order 60, and the judge agreed with, of course, the PPP side that said, look, Order 60 could stand. So essentially, the petition has been dismissed. But that too has been appealed, because again, these are opinions. This is the Chief Justice opinion, and the law or our system provides for us to seek other opinions from higher courts. So that's where we are, guys, for those persons who needed a little catching up.
Yep, and Randy, I am cognizant that so many persons are tuned in, are logged on, are are ringside, and following what came out of the High Court today, came out of the Supreme Court, whether it's the guard at the ATM at the bank, or a seller in Border Market, or a clerk in a store on Regent Street. This case, as the Chief Justice said, as you said, is of national importance, and so many persons, are listening in. And for those persons who might have not had it gone the way you want it to go, we say whole strain. Either way, this court was going to the CCJ. So had it gone one way, that euphoria might have been, that excitement might have been short-lived.
Yes.
Politics is about long distance running. There are some short sprints, yes, we admit and concede. But for the most part, politics is about long distance running. You have to be able to go the distance. And so we say, hold strain, do not lose heart. This is just the first installment. It is heard here first, Randy articulated, goes before the Court of Appeal next, and then perhaps ultimately to the CCJ. And so we are going to be here with you. We've been here with you, Randy, long before the recovery started last year. We're still here, still in it, day after day, afternoon after afternoon, night after night. We're still here, holding strain. And so that's our encouragement to you guys as well.
Yeah, definitely. Just a reminder again to those persons who are continuing to view the live stream that we are awaiting the statement by the leader of the opposition. He'll be on in just a few minutes. They've been giving us word that we're finalizing now. We're ready to go, right? So just hold on for that. Let me see what messages we're getting here. I think we are about ready to go. Sharad, you'll be able to bring that in, I assume.
Yes, as soon as they're ready, we are going to take it. Randy, they're going to come through us, or they're going to come? Are they going to
No, they're coming through. They're coming here. They will be joining us here on the program.
All right, I'm going to wait for Randy to come back. Folks, I seem to have lost Randy there. Apologies again. As Randy said, we are waiting for the leader of the opposition. We want to get some context from his end on the decision of the Chief Justice, Roxanne George Wiltshire, in Decision Day, Election Petition 88, being the judgment being just about half hour ago. The delivery of that judgment concluded, and we are waiting for the leader of the opposition, and we are going to wait for Randy as well to come back, who seem to have been booted from the broadcast unceremoniously. So we're going to hold for that, folks, and continue to gauge some reaction. But just by way of housekeeping, Randy's going to pick up on that coverage a little later on in the afternoon for the Rush, his program that he hosts, and that is usually on around 5:30. And then I'm going to be back at 8 o'clock to bring you some more reactions in the ring. And then we're going to have some other issues to contend with. I have Randy back with me. Randy, apologies there. Seem to have booted you unceremoniously.
Yeah, no problem. I think we're having some problems. As we hear, our team is trying to monitor some of the comments coming through, right? Yeah, trying to monitor some of the comments coming through, as we're also in contact with the office of the leader of the opposition. So we're hoping to bring them in just a few, folks. We thank you for your continued support of what we're doing here. As Sharon would have mentioned, we'll be on at 5:30 this afternoon. We'll be on at 5:30 this afternoon, where we will bring you, we'll unpack some of what, other reactions. We're hoping that we get some other minds, some other legal minds on the program, so they can unpack and talk about the way forward. Because at this point in time, we've heard what the Chief Justice had to say. We will now be getting ready for two appeals of those petitions in the Court of Appeal. And as we were saying all the time, that look, this is just the steps that we need to take. Sharon, microphone. So we're not hearing you, Sharon.
Randy, we do have the leader of the opposition now, and I want us to go to his statement.
Yes.
Great. A very good afternoon, leader of the opposition. The Honorable Joseph Harman is with us. And go right ahead when you're ready, sir.
Thank you very much, Randy. Thank you very much, Sherrod. I just want to read a statement, and it goes as follows. My dear fellow Guyanese, today the Chief Justice has ruled against our petition number 88 of 2020. Today, democracy was stabbed in the heart in this fair land of ours. We must and we will lodge an appeal against this atrocious decision of the High Court. Many of you previously expressed doubt and concern that the court will rule in our favor, given the pattern of its ruling in election cases recently. We continue to advise that the judicial system will rule in accordance with the law. I have myself urged that if we do not have a court whose decisions are sound in law, fair in its application of justice, and perceived as impartial by the society, that critical element which holds us together as a nation will lose its credibility. Today, like you, I am disappointed and I feel let down by our judicial system. But I remain fortified that our hierarchy of courts will correct this clear injustice which has been wrought on the Guyanese people. This is a clear attempt to protect the installed PPP regime from scrutiny and from being removed from government where they have no right being. The elections of March 2020 were flawed and fraudulent. The world knows this. The world has seen this. There was clear fraud. We saw that as plain as day when the boxes were opened at the recount. Missing poll documents, dead people voting, people outside of Guyana recorded as voting, missing ballots, missing oaths of identity, and a whole host of irregularities, discrepancies, and wholesale fraud. And yet this Chief Justice can rule otherwise. Today, when we expected that the legal basis upon which this installed PPP regime would have been swept away and the law of Guyana being stringently and robustly upheld, we have been disappointed again by the decisions of our court. This decision is not about justice. This decision is not about the people of Guyana. This decision is not about what is right. This decision is not about democracy. It's not about you. It's about protecting the status quo, no matter how corrupt that status quo is. The struggle since August last year has been a grueling and painful one. We have suffered so much. So many of you have suffered so much since this installed PPP regime came into office 8+ months ago. Many of you have lost your jobs and livelihood. The country has regressed and reversed into economic decline. People are crying out everywhere. Prices are going up and people don't have money in their pockets. Hospitals don't have medication and crime is on the rise. These are dark days in our country, but we must not give up. I must take a moment to express our thanks to our legal team, Mr. Roy Ford, Senior Counsel in particular, and Mr. John Jeremy, Queen's Counsel. The system has ruled against us. The system has ruled against you. You had a solid case, but the system decided otherwise. Comrades, I must especially thank you for your perseverance, your resilience, your confidence, and your wherewithal. This is not the end. We will appeal this at every level until justice is delivered to us. We must keep hope alive. We must continue to fight. We will continue to work to remove this installed PPP regime. Through it all, you have been resilient, and I salute you. We must continue to be resilient and stand firm against injustice. We fight against principalities and powers, but our struggle is just and righteous, and the struggle must continue. Today is a dark and ominous day for democracy in Guyana. The ruling of the court must strike fear in the heart of all democracy-loving people in Guyana, in the Caribbean, and around the world. We have continuously called on our people to keep the peace, to remain calm, and to uphold the law. Today, however, we have witnessed once again the judicial system failing our people. The APNU AFC cannot and will not be held responsible for the reaction of the victimized, disenfranchised, marginalized masses. We will continue to fight and wish to make it very clear that all options remain open to us. It was Dr. Martin Luther King who said that injustice anywhere is a threat to justice everywhere. I urge you, I plead with you to keep the faith. We shall overcome. I thank you.
There we have it, Leader of the Opposition, Mr. Joseph Harmon. I don't know if he's open for a question, but I would rather suspect he might be busy at his end.
Yeah. Thank you very much to the Leader of the Opposition.
And Randy, I know you're going to want to unpack some of what's said there.
Yeah, I think that is consistent with what we were saying, Sherrod, that, and just like the senior counsel Ford said, that, the court has come down against us, not in for us today, but the system allows for us to appeal, and that will be done. The Leader of the Opposition there using the word injustice a lot, because the reality is that the evidence there, people are, wondering where the evidence is there, especially in that petition 99. That is not allowed to be heard. And this is why, of course, they will fight tooth and nail for you, the people out there, not to hear the evidence. Though we have been presenting those pieces of evidence to you since the recount started. And we have gone through ad nauseum, shared all of the fraudulent things that we would have uncovered in that election. So at the end of the day, I will leave you with the famous words of Anil Nandalal that fraud is fraud.
Yeah. And Randy, it's important to underscore that the Chief Justice decided not to go in the way of Charan Das to topple this government. But in the words of Desiree Bernard in the Aubrey Norton case, in her summary to the Joe Hamilton case as well, Desiree Bernard said, who was then Chief Justice, that it is imperative that trust and confidence continues to be reposed in GCOM, and that GCOM must do everything to dispel that lack of confidence and any perception that GCOM may be acting unfairly. And when we opened those ballot boxes, as the Leader of the Opposition articulated there, and what was found in those ballot boxes, GCOM and the courts has to do all in their powers to dispel the lack of confidence that is now going to be reposed in GCOM, and the perception too that it is acting unfairly.
Yeah, definitely, Sharon. And I want to, as we conclude, bring to the attention of the Guyanese people. I put forward for your attention, we in court, the pieces of evidence, not only of the fraud that occurred, exhibit A, B, C, D, all of them, not only a fraud, but the pieces of evidence that point to the fact that the PPP, the People's Progressive Party, either don't know what they're doing or is intentionally turning this country upside down.
Yeah, correct.
All of what, as I said, flowed from what happened on March 2nd and thereafter.
Correct,
And the
Randy.
actions of GCOM and those persons involved. Now, we are saddled with an administration
that is badly failing.
Right.
Badly failing on every
failing
front.
on all the fronts. We
Badly
have what I
failing,
like to
failing badly. Yeah.
right. I like to term it as the economics of corruption.
Mm.
That is how I like to term it, because we look at all of the sectors, guys, sugar, sugar, we look at the oil, Gaia, we look at GPL, we look at all around.
Yeah.
Look at education. All you're seeing is an economics of fraud.
Yeah.
Riddled with kickbacks and secret deals and nepotism.
Yeah.
And this is a country that we saddle with. And let's add another piece to you. We look at the health sector. We look at how badly they're failing in the health sector. Simple things are not in the hospitals. I mean, I'm going here, and many persons may know this, but many persons don't necessarily see what is happening in front of them. We are sitting as the proverbial frog in this ever boiling water that is slowly, the temperature is slowly increasing, and we are seeing the signs in front of us in this country of this administration that, as I said, either don't know what they're doing or is intentionally turning this country upside down with their economics of fraud and the economics of corruption. Sorry, but I mean, that is what we are saddled with, and if you look around, it's clear as day. Some of us are just blinding our eyes to it for some reason.
Yeah. Randy, and I agree with you on all counts, because we've been outlining during the rush, your program in the afternoons, in the ring in the evenings, and other forums. And the people in this country are seeing for themselves in every front, in every sector, the decadence and degradation from the last 5 years, from where we were and where we could have been by now.
Yes.
And the Guyanese people will have their own interpretation on what this judgment means and what was said, and on ultimately the legacy of the Chief Justice. But I know you were going to unpack some more on this ruling on Election Petition 88 that was just handed down by the Chief Justice, Roxanne George Wiltshire, on your program, The Rush, this afternoon. You come on at 5:30 or 6, Randy?
We'll be on at 6 this afternoon.
At 6 o'clock, and I know you're going to have some guests, some guests, some legal minds to help you unpack these many issues, and then I'm going to be back at 8 o'clock to pick up on this another issue.
And just another programming note, as we talk about legal minds, we see that former Minister and MP Annette Ferguson has taken Mr. Hamilton, Joe Hamilton, to court. The same, and I'll talk about this afternoon.
And there's also recently won a liable case in court, and that was an action against Mr. Jagdeo, installed Vice President Bar Jagdeo.
Yeah. And, quite interestingly, Sherrod, Mr. Joe Hamilton is being sued by Annette Ferguson for the exact same words used by Jagdeo. Can you believe that?
Yeah. Yeah.
Can you believe that? You have to be some sort of lunatic to just see in plain public view, your vice president losing a case against this for the same way. This is the man stood and said the same thing that Jagdeo said, and Annette said, "Wait, you lie. Another one? The man said another one." So now she's suing for 50 million.
We're gonna watch and see where that goes.
That's crazy, and I want to get Annette on to talk about that. How interesting Mr. Joe Hamilton would show. And these are the leaders that we have. These are the people that are running our country. Imagine that.
Yeah. Well, Randy, I commend The Rush this afternoon at 6 o'clock to our viewers who want to get a broader context and a deeper understanding of Chief Justice Roxanne George Wiltshire's ruling on Election Petition 88.
Yes, definitely. And to our viewers who are part of this broadcast this afternoon, we thank you, as usual, for being a part of what we're doing. As I would normally say, I'll do my outro first because Sherrod is operating today.
I'm giving you the last word.
Let's continue to work for national development, and do stay safe.
Stay safe.